teaching, today we are going to compare and contrast the respective approaches of the English and Malaysian law of contract towards the doctrine of duress and undue influence. What are the doctrine of duress and undue influence? Duress established when the consent of a contracting party may have been obtained by some form of pressure which the law regards as improper. Undue influence is an equitable doctrine and is applied in situations that are not covered by common law duress.
Duress refers to a situation whereby a person performs an act as a result of violence, threat, or other pressure against the person. Black's Law Dictionary defines duress as any unlawful threat or coercion used to induce another to act in a manner they otherwise would not. Duress is pressure exerted upon a person to coerce that person to perform an act that he or she ordinarily would not perform. There are three principal forms of duress, separated by the nature of the threats. The first form of duress we will be discussing is duress to the person. This form of duress arises in cases of actual or threatened physical violence or unlawful constraint directed at a contracting party or employees for whom he is responsible or his family members. The principle was laid down in Barden against Armstrong that the victim must show a causal link between the alleged duress and the entry into the contract so to be set aside to be able to avoid the contract on grounds of duress. But the duress needs only to be a cause, but not the sole or the but-for cause of entry into the contract. So long as the threat is just one of the reasons a person enters an agreement, even if not for the main reason, the agreement may be avoided. The onus was on the guilty party, in this case Armstrong, to show that his threats contributed nothing to Barton's decision to sign. As Lord Wilberforce has stated, the first step required of the victim is to show some illegitimate means of persuasion was used. The next necessary step would be to establish the relationship between the illegitimate means used and action taken. The second form of duress would be the duress to goods. The traditional position of common law was that threats in relation to goods are insufficient to render an agreement voidable for duress. Such in the case of Skeet against Beale, when the plaintiff, who was the landlord, seized goods owned by the tenant and threatened to sell them unless he entered an agreement for repayment of the sums owed. The tenant agreed to the repayment terms, but then sought to have the agreement set aside for duress. It was held that duress to goods will not suffice to render a contract voidable. The modern position, however, recognizes duress of goods, which makes these types of contracts voidable, and Skeet against Beale is no longer good law. And last but not least, economic duress. Economic duress arises when a party uses their superior economic power in an illegitimate way so as to coerce the other contracting party to agree to a particular set of terms. Actual or threatened breach of contract is a civil wrong, but common law until recently did not recognize such a threat as sufficient to make a variation of a contract, thereby induced voidable. The doctrine of economic duress was first canvassed by Justice Kerr in the Sibuan and the Sibutre. The defendants had chartered two vessels from the claimant and told the claimant that they would go bankrupt if they did not lower the cost of charter. The claimants would have suffered huge losses if the charters were terminated and therefore agreed to the lower rates sought by the defendants. Whilst the contract was not held to be voidable for duress, but only ordinary commercial pressure, Justice Kerr did state that where there exists coercion of the will so as to vitiate consent, it should be possible to set the contract aside. In Pao On against Lau Yu Long, the Privy Council identified four factors to consider in assessing whether economic duress was present. The first, did the person claiming to be coerced protest? The second, did that person have any other available course of action? Third, were they independently advised? And fourth, after entering into the contract, did they take steps to avoid it? However, the focus shifted in the Universe Sentinel. The ITWF proposed the lifting of blacklists if the ship owners entered into two collective agreements and made a payment towards welfare fund administered by the ITWF. The owners made payment and later sought to recover such payment on grounds of duress. It was held in the House of Lords that early case law had been wrong in looking only at coercion of will so as to vitiate consent. And thus, the focus shifted to also consider the legitimacy of the pressure applied and the compulsion of will, which is the absence of practical choice available to the victim. As the remedies for duress, the only remedy available for the victim is rescission of the contract, subjected to the usual bars to rescission, of course.
We will now look at the Malaysian law of coercion. Under Section 15 of the Contract Acts of 1950, coercion is, by definition, committing or threatening to commit any act forbidden by the Penal Code, or the unlawful detaining or threatening to detain any property, to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. It should also be noted that it is immaterial whether the Penal Code is or is not enforced in place of the coercion is employed. So, what are the elements to coercion? There are two broad categories under the first element of acts which constitutes coercion. Firstly, the committing or threatening to commit any act forbidden by the Penal Code. This scope is wider than the common law of duress, but does not cover tortious or any other civil wrongs. Secondly, unlawfully detaining or threatening to detain any property. This too is also wider than common law, because duress of goods is expressly stated. Secondly, coercion must be to the prejudice of any person, where the prejudice here suggests some detriment to the innocent party. Last but not least, there must be an intention of causing any person to enter into an agreement. As with common law, the coercion must cause the entry into the agreement. Next, we shall look at the application of duress under the umbrella comparison of coercion. In regards to duress to person, Malaysia applies English law, and it follows the case of Barton versus Armstrong. But with duress to goods, this is expressly recognized in Section 15 as it is stated, or the unlawful detaining or threatening to detain any property. There is more to the effect of rescission under the Penal Code. Section 65 of the Contract Act 1950 states that the other party is excused from further performance, rescinding party restore any benefits received under voidable contract. And Section 66 states that contract becomes void and the party receiving advantage under the contract must restore any advantages received or make compensation. And also in Section 76, contract has been rescinded for breach, rescinding party entitled to compensation for any damages sustained through non-fulfillment contract. So, in Malaysia, it seems that coercion is pretty well defined and provided by the Contract Act of 1950. A wide range of offences are covered, and the law is wider than English common law of duress, such as duress to goods, which is expressly provided in Section 15. But Section 15 does not state that the person committing the coercive acts must be a party to the agreement. This ambiguity is still a point of contention even till today.
Now we are going into the comparison between English and Malaysian law under duress and coercion. First of all, Malaysian law coercion has a wider scope than English law duress. This is because the Penal Code in Malaysia covers a wide range of criminal offences. Furthermore, coercion of Malaysian law is also wider than common law duress, as duress to goods is expressly recognized in Malaysia. In contrast with the Malaysian law of coercion, prejudice of any person is not mandatory in duress of common law. Besides, intention is also not an integral part of duress of common law. In duress of the person, the landmark case of Barton and Armstrong laid down the principle that the duress need not to be the sole reason for entry into the contract. It is sufficient if the threats were one of the factors that influenced the victim to enter into the contract. This principle applies similarly in the Malaysian law. Let's now move on to the aspect of the duress of goods. The position of duress to goods under the English common law is slightly narrower compared to the definition of coercion provided under the Section 15 of the Contracts Act 1950. The current position of duress of goods under the English common law is that a threat made in relation of goods may render a contract voidable. If I should be compelled to sign a contract under an imminent threat of having my house burned down, or a valuable picture slashed through without any threat of physical violence to anyone, I do not think the law should uphold the agreement. This statement was stated by Kerr Justice as an obiter dicta in the case of Siboan and Sibotre. Besides, in the case of the evil luck, it was stipulated by Lord Gough that the case of Skip and Bill is no longer a good law since the case of the Siboan and Sibotre. Next, we will be discussing about the aspect of economic duress. Unlike the common law where the four factors to be considered for economic duress were evidently laid down in the case of Pawon and Lau Yu Leong, the economic duress is not expressly stated in Section 15 of the Contract Act 1950, as the definition of coercion is very limited. The High Court of Malaysia held that the Contract Act 1950 does not provide for any form of coercion other than as defined by Section 50. However, some authorities had appeared later on and proved that the economic duress is recognized in principle. Under English law, contract is voidable at the option of the victim if duress is established. In other words, the innocent party may choose to either affirm or rescind the contract. On the other hand, the effect of coercion is covered under the Contract Act 1950. For instance, Section 19 of the Contract Act 1950 stated that the contract is voidable at the option of the party whose consent was not free, and Section 2, Subsection 1 stipulated that only party whose consent was not free has the right to have the contract voidable. Effect of Section 19 is the same as the equitable remedy of rescission available for duress in English law. Therefore, the same bars to rescission will apply in Malaysia too. In conclusion, duress in English law is a complete common law defense, and it is operated in favor of those who committed tort because being forced or compelled to do so. However, in Malaysia, coercion is a defense against committing an act forbidden by penal code. After taking into account all the comparisons above, it is suffice to say that application needs to have its limits and some developments need to be done before being relied on.
Now I would like to proceed with the doctrine of undue influence. Undue influence is an equitable doctrine which only applies in situations not covered by common law duress. There is no precise meaning of undue influence. However, the doctrine illustrates that influence itself is acceptable. It is only when it becomes undue that the law will intervene. Once a contract proof was formed under undue influence, the contract becomes voidable. The two major classifications under undue influence are actual undue influence and presumed undue influence. Actual undue influence occurs when one party induce another to enter into contract by an actual pressure which equity regarded as improper but does not amount to duress at common law because the absence of the element of violence. In the case Royal Bank of Scotland and Ithridge, the court had set out the element of actual undue influence. Firstly, it is an equitable wrong committed by the dominant party against the other. Secondly, it must be unconscionable for the dominant party to enforce his legal rights against the other. There must be some express conduct overbearing the other party's will. Actual undue influence does not depend upon some pre-existing relationship between the two parties. Lastly, he would allege actual undue influence must prove it. No advantages need to be shown under actual undue influence as long as the victim had been induced to carry out transactions he did not freely and knowingly enter into. In the Malaysian context, everything under undue influence is codified. The definition of actual undue influence can be found under Section 16, Subsection 1, which states a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one party is in a position to dominate the view of the other and use that position to obtain an unfair advantage over the other. However, it is not entirely clear whether the clear-cut distinction between actual and presumed undue influence found in English law is applicable within the scope of Section 16 of Contract Act in Malaysian law. All three subsections to Section 16 proceed on the basis of relations subsisting between the parties. In English law, for actual undue influence, there need not be any pre-existing relationship. Perhaps it is more accurate to say that in English law, there need not be proof of any history of influence. In the case of Pusaturai and Kanapa Chetya, alleged that his maternal uncles had influenced him to execute a deed of sale and sought to cancel the deed. The court held that there was no undue influence proven.
The significance of the distinction between the two categories, presumed and actual undue influence, has been much reduced in English law as a result of a decision of the House of Lords in Hendrina. The two main principal views of undue influence are that the focus is on the position of the claimant and that the basis on which the court is given relief is the impairment of the claimant's decision-making process, which is caused by the excessive reliance dependent upon the defendant. And this is seen in Burks and Chin Nyuk Yin, 1995. The second position is of the defendant, which requires some wrongful conduct on the part of the defendant. Emphasis is placed on the need for an abuse of the position of confidence taking advantage of the claimant. In some recent cases, judges have placed emphasis on the need of some wrongful conduct on the part of the defendant. So, presumption of undue influence appears to have three elements to a case of presumed undue influence. The claimant must prove that he placed trust and confidence in the defendant in relation to the management of his affairs. In Malaysia, this view is affirmed under Contracts Act Section 16, subsection 1, as illustrated in the case of Posathuari versus Kanapachetia and Ors. Here, the privy court held that it was not sufficient to have a mere influence. The influence must be undue, in that the dominant person has used his position to obtain an unfair advantage. A contract is said to be induced by undue influence where relations subsisting between the two parties are such that on the parties is in a position to dominate the will of the other and uses the position to obtain an unfair advantage. So in both English and Malaysian, there are certain relationships where law presumes irrefutably that one party had influence over the other, and that this presumption must be distinguished from the evidential nature of the presumption of undue influence. This is seen in the case of Royal Bank of Scotland, PLZ versus Atridge. Here, for instance, the presumption that there is undue influence would be with a parent-guardian relationship or child to a trustee or beneficiary to a solicitor. But relationships of husband and wife are not included. In the Malaysian context, it's also included that mental capacity, age, illness, and mental bodily distress is encompassed in undue influence under Contract Act 16, subsection 2B. The claimant must prove that the transaction calls for explanation. And this is seen in the requirement which is first appeared in the speech of Lord Scarman in National Westminster Bank Place versus Morgan, 1985. So the requirements in Malaysia was applied in the case of Polygram Records CDN Bahad versus the Search of Anwar, 1994. The case involved a group of young singers identified as the Search who had entered into two similar written recording contracts with the plaintiff. The defendants, which are the singers, alleged that the second contract was made under undue influence, successfully establishing existing of undue influence. They now had to prove manifest disadvantage. It was held by the High Court that considered whether the second recording contract had indeed manifested disadvantage as allegedly by the defendants held, but it was not. The judge went to say that even if the defendants had not had the requirement to prove the manifest disadvantage, they would still have a viable contract due to the affirmation of the contract. So thirdly, the defendant's attempt to rebuke the influence of undue influence that has arisen from proof of claimant of the existence has two main elements, which is this presumption from relationship, such as seen in the case of Alkert versus Skinner, where a disciple of a cult gave up all her property and gave annual money to the Mother Supreme, where she claimed that she was under the undue influence of the church due to the fact that she had no right to look for legal representation or outside counsel. So the only possible way of disproving undue influence, both in presumed undue influence, according to Dixon J. and Johnson versus Boutros, is that the presumption of undue influence is rebutted by showing that the defendant took no advantage of the donor, but that the gift was the independent and well understood act of a man in a position to exercise a free judgment based on information as full as that of the done. So even though you can prove that there is no there's no legal advice or outside counsel, it does not necessarily mean that undue influence is not assumed. So ultimately, Malaysia holds the exact same stand with the equitable nature of the doctrine of undue influence as English law so is stated in section 16 of the Contracts Law, and has been interpreted flexibly while bearing in mind the Malaysian context. This has been stated in the case of Tengku Abdallah ibn Sultan Abu Bakar and Ors versus Mod Latif bin Shah Moh and Ors and other appeals. Here it was expressly said that it has been recognized that the section does not differ from English law upon the subject of undue influence, and decisions of English courts are therefore a useful guide to the approach that our courts ought to adopt to the interpretation of section 16.
So now let's look at undue influence by a third party from the English and the Malaysian law. Now let's start with the English law. The general rule is that contract established due to undue influence from a third party, one who is not a party to the contract, will be voidable. Now let's look at the requirements as stated in CIBC Mortgages PLC and PID in 1994. The first requirement is that the third party was acting as the other party's agent. Secondly, if the party had knowledge, actual notice, and constructive notice of the undue influence exerted by the third party. Now let's look into constructive notice, which is the third requirement. In the case of Barclays Bank PLC and O'Brien, now this is a case of misrepresentation by a third party. Now here the wife charged her property to bank based on misrepresentation made to her by her husband, and the issue here is that because of the husband's misrepresentation towards the wife, could the contract between the wife and the bank be vitiated? The courts held that the charge was voidable because, based on the facts, the bank had constructive notice of the husband's misrepresentation. Now let's look into the steps to constructive notice as stated by Lord Brown Wilkinson. Now there are two stages to this. The first stage is that a creditor is put on inquiry when a wife stands surety for husband's death if, firstly, the transaction is on the face of it and it's not advantageous to the wife. Secondly, there exists substantial risk that the husband had in procuring a wife to act as surety, committed a legal or equitable wrong that entitles the wife to set aside transaction. Now in the second stage, it says that where a creditor is put on notice of the risk of the misrepresentation or the undue influence by the principal debtor, the obligation of the surety will be unenforceable if the undue influence, misrepresentation, or some other legal wrong by the principal debtor with regard to the surety is proven. And secondly, if the creditor has failed to take reasonable steps to be satisfied that the surety entered into the obligation freely and with knowledge of true facts. Also, the creditor will normally be regarded as having taken reasonable steps by warning the surety, not in the presence of the principal debtor, of the amount of the surety's potential liability and risk involved, and advising the surety to take independent legal advice. Now let's look into the detailed guidelines for the banks when dealing with sureties. Now this is stated by Lord Nichols in the case of Royal Bank of Scotland and Edridge No. 2. So what happened here is that there was a further refinement to steps laid out by Lord Brown Wilkinson in the previous case. So in stage 1, banks are put on inquiry in every case where the relationship between the surety and debtor is non-commercial. And in the second stage, transactions should be explained to the surety by an independent advisor, usually a solicitor, and there are certain steps to be taken by the bank. Firstly, they should communicate directly with the surety to see if she wishes to use a solicitor. Secondly, the bank must provide such solicitor with full financial information relating to the transaction. Thirdly, if the bank suspects that the surety has been misled, the solicitor must be informed of the suspicion. And lastly, the bank will require from the surety solicitor a written communication that the nature of the transaction and its practical implications have been fully explained to the surety. Now, more for the second stage, the bank will also have to assume that the surety wishes the solicitor to act for her. There must be a face-to-face meeting between the solicitor and the surety, where the solicitor should explain the transaction and its implication in suitably non-technical language. This means that they have to explain the nature of the documents being signed together with the consequences. Secondly, seriousness of the risk, and making it clear that the decision to give the guarantee is the surety's and hers alone. And lastly, asking the surety whether she wishes to proceed or wants the solicitor to negotiate further on the terms with the bank. Now let's look at the Malaysian side of things. Under the Malaysian context, the application of the common law is highly similar. The case to define this is the Malaysian French Bank and Abdullah bin Muhammad Yusuf and others in 1991. So what happened here is that a plea of undue influence can only be raised by a party to the contract and not by a third party. Nevertheless, a contract resulting from undue influence exerted by a third party is unenforceable, and in this case they applied the principle which was stated in the Bank of Montreal case in 1991. So this conclusion, basically, it's not inconsistent with Section 16 of the Contract Act 1950. It is also based on common law. So as a comparison, generally the undue influence from a third party is generally similar on the basis of application, as the Malaysian law follows the common law very, very closely.